Thank you, Adam, for joining us. I do want to just introduce Adam, thank everyone for being on the call on a really interesting issue. This was a case that was up in the New Jersey Supreme Court yesterday. I'm going to let Adam sort of describe the parameters of what was at issue, but as a general matter, it was on the scope of what constitutes a protected employee action under CEPA and whether that should cover the performance of regular job duties. Adam drafted the amicus that was submitted on behalf of the New Jersey Civil Justice Institute and represented our organization at oral arguments yesterday. He is a graduate of Harvard College and Harvard Law School and currently a partner at McCarter English in Newark, which is also fantastically hosting our Paul Clement event in February. Adam represents employers on a variety of commercial litigation and employment law-related matters, including whistleblower protection issues. He has been involved in over 15 decisions by the New Jersey Supreme Court, New Jersey Appellate Division, Third Circuit, and Second Circuit Courts of Appeals. And we very much appreciated his efforts at the New Jersey Supreme Court yesterday and his work on this case and for joining us today for this teleforum. Adam?
Thank you. And thanks to everyone for joining the call. This has been a very interesting case, and it was a very interesting oral argument yesterday. Let me give you all an overview of the case and the issue, and then I'll describe the argument yesterday, and then we'll take questions. The plaintiff is Dr. Joel Lippman, who is a medical doctor and has held a series of positions with the defendant. The defendant is Ethicon, which is a subsidiary of Johnson & Johnson. And Ethicon sells medical devices such as dissolving sutures, gels for closing wounds, cardiac devices, and so on. Lippman's positions included being the Vice President of Medical Affairs and the Chief Medical Officer. He was responsible for reviewing clinical trial data and determining whether a product should be put on the market, whether reviewing data and participating in a committee called the Quality Board, which was a board that Ethicon created, bringing together executives from different departments with different areas of expertise to review product quality and safety issues and to determine what actions, if any, should be taken based on information that came in from the field about the product. Those actions could include sending letters to health professionals who use the products, doing additional research, notifying the FDA of issues with the products, modifying product warnings, or doing recalls. And Lippman's role, given his background as a medical doctor, was to provide medical expertise to the Quality Board and to participate in its deliberations, and the board would ultimately decide what should be done. Now, Lippman claimed that he blew the whistle when he advocated in some of these Quality Board meetings over a number of years that certain Ethicon products had safety issues and should be recalled. And Ethicon said that when Lippman raised these concerns about safety or recalls of products, the Quality Board reviewed the issue and discussed it, and ultimately everybody agreed on what to do. Lippman raised issues about 6 or 7 different products. Sometimes the board agreed to study the issue further. Sometimes they agreed to send a letter to physicians. And several times everyone agreed that a recall should be done. Ethicon's position is that Lippman's work on the Quality Board had nothing at all to do with his termination, and that he was terminated because it was discovered that he had had a romantic affair with a woman who worked in his department, which among other things, led to a complaint by another employee that Lippman was showing favoritism towards the woman with whom he was having an affair. That issue, the issue of what was the real reason for the termination, was not an issue that the Supreme Court was considering. The Supreme Court considered the issue of whether Lippman's conduct, as he described it, raising safety concerns in the course of performing his job duties as a member of the Quality Board and as Vice President of Medical Affairs, whether that conduct was protected by the state whistleblower statute, whether performing your regular job duties can be whistleblowing, and if so, under what circumstances. The case was brought under the Conscientious Employee Protection Act, known as CEPA, which has been described as the broadest whistleblower statute in the country. It prohibits an employer from retaliating against an employee for engaging in protected conduct. And protected conduct is defined in the statute to include three primary categories of actions. All of them relate to what the statute describes as an activity, policy, or practice that the employee reasonably believes is in violation of a law or regulations or a clear mandate of public policy, or may be fraudulent, or in a medical setting if it affects the quality of patient care. So if an employee has a reasonable belief that an unlawful or improper activity, policy, or practice is going on, then the statute says the employee engages in protected activity if the employee does one of three categories of things. One is if the employee discloses or threatens to disclose the activity, policy, or practice to a supervisor or to a public body. Number two is if the employee provides information about the activity, policy, or practice to a public body or testifies before a public body. And number three is if the employee objects to or refuses to participate in the activity, policy, or practice. And it was this third category that was at issue in the case, though the oral argument also touched on some situations involving the other categories. So it focused on this third category because Lippman claimed that he had objected that certain products were unsafe and had to be recalled. He did not claim that he had disclosed the information. The information had been brought to the company and was disseminated to several people in the company, including the members of the Quality Board. His argument was he had objected in the course of Quality Board meetings that the products were unsafe and had to be recalled. In the trial court, those claims were thrown out on summary judgment. The court held that when Lippman raised the issues about safety, he was not objecting, that he was just performing his regular job duties. The appellate division reversed that and said that employees with responsibilities for safety and compliance issues are watchdog employees. That was a term that the appellate division came up with. And that watchdog employees are covered by the CEPA statute. But in order to bring a claim under the CEPA statute, they have to take an extra step and show that they exhausted all means of securing the company's compliance with the law or with public policy. Both sides appealed, and the Supreme Court decided to review the case to decide whether the whistleblower statute applies to employees who have responsibilities for safety and compliance issues, and if so, how it applies, including whether this exhaustion requirement applies. Just a quick summary of the elements of a CEPA claim. In order to establish a prima facie case under CEPA, the employee has to show that he or she engaged in protected activity, which I described. Second, that they reasonably believe that the activity, policy, or practice violated the law or was fraudulent or in violation of public policy. That the employer took an adverse action, which could be a termination or other forms of discipline, and that there was causation, a connection between the adverse action and their protected activity. In the Supreme Court, the defendants argued that the language of the statute requires an objection, and that if an employee expresses a concern about safety or compliance issue while performing their regular job duties, that does not constitute an objection, and that the employee is just performing their job. The defendant also argued that the statute requires that the employee must object to an activity, policy, or practice, and that when an employee is involved in the decision-making process through a deliberative committee or board, there's no activity or policy or practice until a decision is made about what activity or policy or practice the company should follow. The defendant also argued that Lippman was a decision maker. He was one of the members of the committee that was going to decide these issues, and that since he was involved in making this decision and debating the issues, he couldn't object until a decision was made because there was no activity, policy, or practice until that point, and that the statute doesn't cover an objection to a potential activity, policy, or practice. The defendants based their arguments on the language of the statute and argued that the word object means more than just expressing a concern or just doing your job, and it requires opposing an activity, policy, or practice, and not just a potential course of action. The defendant relied on a number of appellate court decisions over the last 5 years or so, which have held that employees doing their jobs were not blowing the whistle when they raised security concerns. Some of those cases involve, for example, a security supervisor who learned that blueprints for train stations had been discarded in the trash and were accessible to the public and was concerned that that presented a security risk. The court held that the security supervisor's job was to raise those concerns, and that by doing so she didn't raise an objection. There were a number of cases involving managers who disciplined or terminated employees they were supervising because those employees engaged in illegal activity, and the court said that that was not objecting to unlawful activity. It was doing the job of supervising or managing the employees. And there have been a number of cases along those lines. The defendants also made several policy arguments in the Supreme Court. And a number of the court decisions that I just mentioned expressed the first concern, the first policy argument, which is that if an employee's regular duties involve safety or compliance issues, and then they're disciplined or terminated for any reason, that the employees can always claim that the discipline or termination was in retaliation for the raising concerns about safety or compliance issues because they're doing that all the time. So if, for example, an employee's job is to write product safety warnings, and then that employee is terminated, that employee can always claim that the termination was because they were constantly expressing concern about or articulating safety issues about the company's products, and that this kind of automatic CEPA claim would create a class of specially protected employees, and it would make it hard for employers to manage the performance of those employees. If they're doing their job poorly, it would be difficult to replace them, and that would lower the level of performance in these critical job functions. The second policy argument was that if these employees are covered by the CEPA statute and they can always bring a CEPA claim in the event of any adverse action, then it creates incentives for the employers to cut back on these safety and compliance positions. we cited in our amicus brief a number of studies showing that when companies adopt more substantial, more robust safety and compliance programs, that yields better results for the businesses in terms of their safety and compliance record and in terms of their profits, because they avoid quality and safety issues, they avoid recalls, etc. And if adding to these programs and committees leads to more CEPA litigation, then that creates incentives for companies to reduce the number of positions that have these responsibilities, to make these committees less deliberative, to push these positions lower down in the corporate structure, or to move these positions outside of New Jersey to other places where the whistleblower statutes are not so broad, or where there may not be any whistleblower statutes. And we emphasize that the quality boards and safety committees are largely optional and voluntary, and companies have lots of discretion about whether to make them big or small, whether to give them a lot of responsibility or a little, whether to include people at high levels of the company. And so if by doing so they expose themselves to more CEPA litigation, that would create incentives to cut back on the programs, which would be bad for the businesses and also bad for the consumers who use their products. The third policy argument was that if the expressions of concern about safety issues in these quality board or committee situations gives rise to CEPA litigation, it would skew the decision-making process in favor of safety concerns and against considerations such as the potential benefits that new products may have for consumers. For example, patients who might benefit from new medications. And if concerns about safety are protected, but arguments about benefits of products are not, that would create incentives for companies to be more cautious, approve fewer products, and or withdraw products more quickly, and that CEPA was not intended to skew the decision-making process in this kind of way. The plaintiffs argued that employees who have responsibility for safety and compliance are in the best position to know what's illegal or what's unsafe, and they're the ones most likely to raise those concerns. So they're the ones who need protection under the whistleblower statute the most. They also argue that if these employees say that the company can't sell a product or can't take a certain course of action because it's illegal, that it doesn't make sense that they have to wait until the decision is actually made, until the product is actually sold, or the company actually does something illegal in order to be protected. They argue that if they say something's illegal, they're opposing it, and that constitutes an objection. They also argue that the statute covers employees without any exception. There's no exception to the definition of employees. At the oral argument, it was really a very lively oral argument with a lot of questions to the lawyers on both sides. Most of the court's questions really had very little to do with the facts of the case and more to do with hypothetical situations about what might be considered whistleblowing and what the policy impact of their decision might be. One hypothetical that was raised was if an employee is on a safety committee and objects that putting a product on the market will violate the law or will result in injury or death to consumers, and the company terminates that employee because of those concerns, before the committee makes a decision, and then the company goes ahead and decides to put that product on the market, is that an objection that's protected? That got to the question of whether there needs to be a decision in order for there to be an activity, policy, or practice. There were a lot of questions about if the company goes along with the recommendations of the employees who are raising concerns about safety or legal compliance, can there still be an objection? And the defendants argued here that in almost every instance, when Dr. Lippman raised a concern and made a recommendation about what the company should do, that the company went along with that. The quality board agreed, and the company went along with it, and that therefore there was not any objection that was protected under the statute. But the justice posed a hypothetical about a company that would terminate all the employees on the committee who raised concerns and replace them with yes men, and wouldn't that be retaliation for whistleblowing? The defendants argued that companies have lots of good business reasons for creating these safety committees and compliance committees, and lots of good legal reasons for doing that, leaving aside the whistleblower statute, that it's good for business, and it doesn't make sense that companies would establish these committees and then undermine them by replacing all the people on them who expressed the concerns that they were hired to express. And we argued that the legislature recognized that it's beneficial for companies to be allowed room to establish these committees and to require that employees only object when when a decision is made, to allow room for these committees to deliberate and debate and argue both sides of an issue. I would say that a number of the justices seemed skeptical about these positions and seemed bothered by the idea that an employee could express a belief that a potential action would be illegal and then would not be protected and could be fired without any protection or consequence. On the other hand, the justices seem to recognize that the problem, there would be a problem if employees in safety or compliance positions had essentially an automatic CEPA claim anytime they were terminated or disciplined. And they asked a number of questions to the plaintiff's lawyers about whether it would be the case, if the court adopted the plaintiff's position, that any employee in one of these positions would be able to make out a prima facie case automatically anytime they're terminated or disciplined. And the justices raised the concern about would it ever be possible for an employee to be terminated without CEPA litigation if their job included expressing concerns about safety issues. A number of the justices asked if these employees would be covered. Wouldn't it be the case that employees could bring these claims and would always get to a jury on them, that there wouldn't be any ability to obtain summary judgment, because since they're always raising safety concerns as part of their job, anytime they're terminated, that would be close in time to their performing these types of responsibilities and expressing these concerns, and they'd automatically get to a jury. And they asked, wouldn't that create a chilling effect on companies who are considering disciplining these categories of employees when they're doing their job poorly? One interesting question that came up is, and this was based on an argument made by the defendants, is if an employer believes that an employee in one of these positions is being too conservative, is giving bad advice, can they be terminated without a CEPA lawsuit? And an example that was given is, suppose the general counsel of a company gives advice to the CEO that a certain activity would violate the antitrust laws. And that may be an issue about which reasonable minds could differ. So the advice is reasonable. He's got a reasonable basis for a belief that the conduct would be illegal under the antitrust laws, but it's a conservative opinion, and ultimately it turns out to be wrong. The question was, can the general counsel in that situation be terminated for giving the wrong advice in the course of doing his regular job duties, or can he assert a CEPA claim because he reasonably believed that the conduct would be unlawful, and he expressed that opinion even though that was part of his regular job duties, and he was terminated because he raised his concern about unlawful conduct. I think that illustrates, is a good illustration of the potential that covering employees in these types of positions can create difficulties for employers. And the justices did seem sensitive to that. They also asked if everyone at the company agreed with the position that the employee was raising, the safety concern, can the employee be considered to have objected? And the facts supported the facts in this case presented a number of examples of that, where in a quality board meeting, Dr. Lippman advocated the recall of a product, and everyone else agreed, and the product was recalled. They also asked if the statutory term object could be read reasonably to mean something beyond just doing your regular job duties, and whether it suggested that there should be some kind of requirement that the employee go beyond the regular job duties, such as the exhaustion requirement that the appellate division imposed, although everyone seemed to acknowledge that the statute itself doesn't talk about any kind of exhaustion requirement in this context. So that's the overview of the argument, and at this point I'll open it up for questions.
As you said, we're going to take questions now, and with that, I'm going to start things off with a question I had emailed to me. Which justices were actually sitting on the case yesterday?
There were 5 justices. A full court would be 7. They were Chief Justice Rabner, Justice Solomon, who's the newest justice, Justice Lavecchia, Justice Fernandez-Vina, and Justice Albin.
So thanks, Adam. I had a question about the ease, the sort of the concern about automatic CEPA litigation, and it seems like there are, and this was specifically in the pharmaceutical context where there were concerns, and I think you made this point well at oral argument, that there are significant trade-offs in both directions in terms of the benefit of a product versus the potential risks, and this idea that there's nothing that's sort of uniformly beneficial, and that is kind of a policy choice. And I guess this is something that they were getting at a little bit, but what do you think about that as a sort of that when you hire people to evaluate the costs and benefits, that is a sort of a core policy element, a sort of a core business model element in a pharmaceutical company, sort of evaluating the costs and benefits of a particular product is I'm not doing a good job of explaining what I'm getting at, I don't think, but that's not like maybe we should do something illegal, maybe we shouldn't. That's sort of at the sort of the essence of the nature of the business model of pharmaceuticals is evaluating the potential benefit of a given product and sort of the impact that CEPA has on this. And then I guess my follow-up to that is, that being said, how much of that is sort of a policy question that maybe goes at the merits of the CEPA statute itself.
You're right that some of the arguments apply with more force in the context of the pharmaceutical and medical device industries, and the regulations that apply to those industries require companies in those industries to consider certain of these issues, but they don't specify how companies have to go about it. They don't specify that the companies have to set up these committees instead of, let's say, putting those responsibilities all on one person, or that the companies have to include employees with high levels of responsibility and different areas of expertise. Those are best practices that have developed for good business reasons, and also to avoid potential legal issues. But companies have lots of discretion about how to do that. And what we argued is that and I should say outside of the context of those industries, there are fewer requirements to have employees who have responsibilities for those issues. And so there's even more flexibility and discretion about whether to have anyone responsible for these issues and how many employees at what levels and so on. And that there are already lots of incentives for companies to create these committees and boards and to evaluate these issues thoroughly, but that if the CEPA statute is interpreted in such a way that all of these employees have automatic protection under CEPA and can't be managed effectively, and if they're terminated, they are automatically going to have a lawsuit, that creates incentives for companies to cut back on these committees and boards and so on, and that's ultimately bad for the businesses, it's bad for the consumers, and it's really ultimately bad for everybody. And we argue that the legislature took those considerations into account when it put some limits on what constitutes protected activity by requiring an objection, which indicates something more than just expressing a concern or raising an issue. And we argued that those kinds of policy deliberations, policy judgments about where to draw those lines are decisions for the legislature to make in the first instance, with the benefit of a legislative record. They can hold hearings, gather information, and make those policy judgments instead of having those decisions made by courts based on the record of one case. And in this case, the appellate division actually said that this case had given it a mere glimpse into one company in one industry, and acknowledged that they were making their decision on the rules that apply here based on this mere glimpse into one company in one industry. And we argued that policy decisions like this should be made by the legislature based on a full legislative record. The appellate division also framed the issue in terms of product decisions, in terms of a binary choice, that there are only two considerations. One is corporate profits, and the other is consumer safety, and said that companies may be tempted to put profits ahead of safety. And we thought that was a much too narrow way to look at it, and that they weren't considering the other factor that you mentioned in your question, which is the potential benefits of products that companies, particularly in these industries, but in others as well, have to engage in a weighing of what are the potential benefits versus what are the potential risks. There may be some side effects that will cause injuries to some number of people, but on the other hand, the product may be actually a life-saving product for a larger number of people, and companies are required to weigh those considerations and figure out how to what's the right balance. Do you put it on the market with certain warnings? Do you not put it on the market at all? And that if the CEPA statute is expanded to cover the deliberations about these issues, that it will put a thumb on the scale on the side of safety concerns in these deliberations, and that that was never an intended result of the CEPA statute and would have business and policy implications that the CEPA statute was never intended to have. So that's how those issues came up. I hope that answered your question.
Absolutely. Thank you.
Prior to the lower court's decision in Lippman, under what circumstances could an employee like Lippman get CPA or CEPA protection under current law?
A number of courts had held that if the employee was just performing their job, that did not rise to the level of an objection under CEPA. It was not protected under CEPA. And some of those decisions didn't discuss the issue at great length. In some cases, it seemed to mean that when you looked at the employee's actions in context, they weren't, in the context of their job responsibilities, that they weren't raising an objection, that they were, the purpose of what they were doing was just to perform their job. Some of the situations in which that holding was applied were there was a case involving a manager at Starbucks who noticed that some of the temperature gauges in some of the refrigerated food cases were broken, and pointed that out and said that they had to be fixed. She was later terminated and claimed that it was in retaliation for raising this, what she described as a safety concern. The court held that when she pointed out the broken temperature gauges and said they had to be fixed, that she was just performing her job responsibilities to make sure that the store was running correctly and things were being done right, and that that didn't amount to an objection to an unlawful policy or practice. There were other cases where a chief financial officer of an organization cooperated in an audit by a government agency and provided information, was later terminated and argued that the termination was in retaliation for providing information, but the court said that the employee was doing nothing more than he was obligated to do in the course of performing his job. There was another financial person at a company who was responsible for accounts payable or accounts receivable and was making sure that everything was paid correctly, and argued that her quality control efforts were efforts to ensure that things were done legally, and the court said, no, that's just performing your job, doing quality control, and it's not objecting to unlawful activity. So some of the courts employed this principle in a fairly categorical way. If the employee is doing their job duties, their core job duties, then there's no protected activity under CEPA. Other courts seem to view it more as a question of what was the purpose of the conduct, or what was the intent of the conduct. But very few of the courts engaged in a lot of discussion about the reason for this exception or rule that was developed.
For those of us who are not employment lawyers, are there other sections or protections in CEPA? And if so, can you give a brief overview of them and whether or not they were issues in this case?
Sure. Yes, there are a couple of other sections, other types of protected activity. One is disclosing improper activity, that is, activity that's unlawful or contrary to public policy or fraudulent. So exposing that to a supervisor or to a government body, or threatening to disclose that information to a supervisor or a public entity. And then there's also testifying before a public entity or providing information in the course of an investigation. And finally, there's also refusing to participate in an action that the employee believes is unlawful or fraudulent. And as an example of that last one, there was a case involving a nursing supervisor at a hospital, and the nursing supervisor was asked to file disciplinary charges against some employees who had raised questions about misconduct by a supervisor. And the nursing supervisor asserted that the charges would have been false and fraudulent, and so the nursing supervisor refused to participate in filing those charges. There was some argument in the briefs and at the oral argument about these other provisions and whether the rule that's established in this case, whatever it turns out to be, would affect the definition of protected activity under those other sections. The defendants argued that those other sections also suggest that an employee has to do something beyond performing their regular job duties. For example, refusing to participate in an activity or policy or practice indicates that the employee is refusing to do their ordinary job duties, that they're being asked to do something that's either outside of what they would normally do, or that they're being asked to do something and they're refusing. Ordinarily, employees don't refuse to do their jobs. That indicates something beyond performance of their regular job duties. The subsection that protects disclosing information to a supervisor is the situation which I think comes closest to covering conduct that is or may be within an employee's regular job duties. If, for example, the employee has responsibility for reporting information, let's say, for example, someone has a position as an internal auditor at a company and discovers that there's been some embezzlement, and then it's that employee's job to report that to a supervisor. The justices seem to have a hard time accepting the idea that in a situation like that, that the employee's conduct would not be protected. That's a more classic whistleblower type scenario, like the whistleblower at Enron who discovered that the books were being cooked and disclosed that. And one answer to that, I think, is that that's a different section of the statute that talks about disclosing information, not objecting, and that objection means more than just doing your regular job duties. So it's not necessarily the same result under each section of the statute. Each section of the statute is phrased with its own language, and the language has meaning in each section. And another response would be that in disclosing information, it has to be done with the intent to call attention to illegal or unlawful conduct. And just as under the objection clause, it has to be done with the intent to oppose unlawful activity instead of being done with the intent to perform regular job duties. So that's how some of the other sections came up. Another question that raised one of the other sections in CEPA is that the provision of CEPA that protects an employee when they disclose information to a governmental agency there's another section of CEPA that imposes some conditions and requires that an employee, before going to a public agency, must first raise the issue internally within the company, unless the employee can show that by doing so would expose them to harm or that there's an emergency. So there is, with respect to that section, a statutory exhaustion requirement. And the argument was made by the plaintiffs that because the statute actually includes an exhaustion requirement for that section, the fact that there's no similar statutory exhaustion requirement with respect to the other sections means that the appellate division was wrong to impose an exhaustion requirement. And that's when I said before that there was no statutory foundation for the exhaustion requirement. That was what I was referring to.
I had a question about the discussion that we had about as a statutory matter when there's an ongoing practice that an employee objects to. So in the context of not a sort of a should we put this product on the market, but it's on the market and someone objects to that ongoing practice of how that is covered under CEPA.
There are two possible situations. One is a situation that was presented on the facts of this case, which is that there were products out on the market. Information came in about certain adverse events, and the question was raised, and should we recall the product or take some other kind of action? In one of those examples, the product has been on the market for 5 years with a very good safety record, and then within a month there were a couple of adverse reports. And I think in that situation, it depends on how you phrase the activity, policy, or practice, but I think you could certainly say that in fairness to the employer, everyone has to have the benefit of the new information and to the opportunity to make a decision in light of that information. That's the purpose of these kinds of review committees. And up until that point, everyone, including Dr. Lippman, believed that the products were safe for manufacture and distribution, and nobody was objecting to that. Then there's a different situation where there may be some ongoing practice, and let's say it involves one example that was brought up was disposal of hazardous waste or dumping of hazardous waste, and if that's been going on, and then an employee calls attention to that and says, we have to stop this, it's illegal. That kind of objection, the argument would be it's an objection to an ongoing activity, policy, or practice, and there's no issue there about whether a decision has to be made. It's been going on. And in that instance, the example I just gave, I think the statute would ordinarily apply, and that it might apply in more than one way. If the employee is disclosing that information, disclosing that practice and saying it's unlawful, it would fit under that prong of the statute. It might also fit under the objection to an activity, policy, or practice because that's an ongoing practice. But that type of situation doesn't involve the kind of deliberative and evaluative decision-making process that was presented on the facts of this case, and therefore it doesn't present all of the same policy issues and potential negative consequences of discouraging companies from establishing these kinds of boards and committees to review safety and compliance issues.
Well, I have no more questions here for you, Adam. I just want to take a moment to thank you so much for doing the teleforum with us today and for your wonderful work on the brief and oral arguments.
Thank you. I appreciate that. And thanks to everyone who participated and for the questions.